Good afternoon. I'm Mike Helgren in Annapolis in front of the Maryland Supreme Court, and this is where there was a pivotal hearing in the case of Adnan Syed. He was accused in the 1999 killing of his Woodlawn High School classmate, Hae Min Lee, and a Baltimore City judge freed Syed last year. The crux of the argument is whether Lee's brother had the ability to speak in person before the judge who made that decision, and the Supreme Court has to decide whether Syed should be sent back to prison if that was a violation. It's a case involving victims' rights, and both Lee's attorneys and Syed addressed the media today.
Today was an important day for the state of Maryland, and in particular, it's an important day for victims' rights. The Maryland Supreme Court today heard argument regarding victims' rights and what victims' rights mean with respect to the Adnan Syed saga. We do not take a position with respect to Adnan Syed's underlying guilt or innocence. This is not what today was about. Today was about young Lee, who is here today, and his rights to have notice, to be present, and to be heard meaningfully in a criminal justice proceeding. Those rights were violated in this process. Mr. Lee was not given adequate notice, was not given the right to attend the criminal justice proceeding, and was not given a meaningful right to be heard. That's all we're asking for. The Maryland Constitution provides that victims be treated with dignity and respect and sensitivity. Those rights were denied as well here. And we're asking the Maryland Supreme Court to uphold those rights, to send this case back down to the trial court and mandate that the state present evidence, whatever evidence it has, so that we can see that evidence, we can examine that evidence, and you, the public, can examine that evidence so that we all can make a judgment as to what happened here. That's what this case is about, and we're hopeful that the Supreme Court of Maryland does the right thing. Any questions?
I have a question. Mr. Rubin, you said repeatedly that Mr. Lee has the right to be an adversarial check on the state and the defense attorneys in this case. He doesn't have that right in the initial prosecution. Why does he have the right to provide a check and balance out what the court's decision? Why does he get that right in the post-conviction proceedings when during the initial proceedings he doesn't have that right?
In the initial proceeding, the state was playing that role. As was discussed in the court today, you have a very unusual law here in which you align the interests of the state and the defendant entirely. The state moves on the defendant's behalf. The state acts as a zealot advocate for the defendant. The problem here was the adversarial process that existed in the original trial was eliminated completely, and 20 years of appellate law was thrown out in less than an hour. That was the issue, and that's why the victim's role is so crucial.
But if it was if they agreed based on the evidence that was provided in Chambers hearing, that why is that an issue?
Because when a court makes a decision, it's necessary for the public and all parties to be able to review the evidence. It is uncanny unless a particular hearing is closed or there's a reason stated on the record to keep the evidence secret. There is no situation in which you can actually make a decision based on secret evidence. That goes against the entire notion of an open judiciary. So that's what's before this court now.
And I would add one thing. It's important to note that when you are charged with a crime, you're presumed to be innocent. When you're convicted of a crime, you're presumed to be guilty. And in order to overturn a guilty verdict, it's incumbent upon the state to present evidence openly. And it didn't happen here. And as a result of it not happening, we're here today. We simply want transparency and openness in the system, and an ability to challenge evidence if it is challengeable. As Mr. Rubin said, if there is sufficient evidence here to show that the verdict in this question should be called, in this case, should be called into question, young Lee and we would be the first ones to acknowledge that and say that Adnan Syed should be set free. But that hasn't happened yet, and what we're simply asking for is that the state present that evidence.
I was wondering if you or Mr. Lee or anyone would like to say anything in memory of Hay, because I think sometimes the victim can get lost in this, and it's got to be a painful thing more than 2 decades later to be dealing with this and having to come here. So I just wanted to see if anyone had anything to say.
Would you like to say a word about that? No. Look, this is extremely painful, as you say, and this is an ongoing living memory to Hay. Justice should be served in this case. There's been a terrible injustice here with respect to Hay, principally. There may be another injustice with respect to Adnan Syed. That remains to be seen. And what we're here today is to determine, through the Supreme Court ruling, whether or not there's going to be openness and transparency and a true adversarial system in our country and in this case. That hasn't happened yet. And so with respect to Hay, we're living through her to make this possible for victims going forward.
After what you heard today, generally speaking, how confident are you that the Supreme Court is going to uphold that ruling for the appellate court?
Based on what I heard today, I'm confident that the Supreme Court of Maryland is going to adopt our position, is going to acknowledge that our rights have been violated here as victims and as a victim representative, that there wasn't adequate notice, that there wasn't a right to attend, and there wasn't a meaningful right to participate and be heard. I'm confident that the Supreme Court will hold that.
One quick question. The justices kept asking why it's not before the legislature instead of them. Can you just kind of repeat your response to that?
The Maryland Constitution is very clear about what rights should be afforded victims. The Maryland legislature has already provided a statutory scheme that allows very clear rights for victims. So that already exists. That was the argument that Mr. Rubin made today, and again, we're confident that the Supreme Court will hold that.
Following up, do you think that the General Assembly can do or should do anything to add more rights as the invested?
I don't think it's necessary for the General Assembly to do anything because, again, the Maryland Constitution and the statutory scheme as it exists are sufficient. However, if the Supreme Court doesn't rule that way and invites the state legislature to act and pass statutes that are more explicit, then we'll deal with that at that time, but we don't think that's necessary.
Have you spoken to or?
Has the family been updated at all on the ongoing investigation that started all of this?
We know nothing about the ongoing investigation, and that's part of the problem. The state has said there's an ongoing investigation, and for that reason, they can't tell us and can't tell the public details. If there's an ongoing investigation, then the right thing to do is to wait until that investigation is over before it files its motion. It's premature to file a motion to vacate while an investigation is ongoing. So either it completes its investigation and then files its motion, and then the evidence is open, or it waits until that happens.
Have you spoken to or communicated with the new administration and the Baltimore State's Attorney's Office about if this case was in fact remanded for a new vacatur hearing, how it would proceed?
We have not. Any other questions?
I want to make sure I get your correct spelling of your name.
David Sanford, Sanford.
And if the Supreme Court of Maryland does not rule in your favor, what's the next step?
The next step would be to go to the state legislature. At some point, this has got to be made right. We're hoping that the Maryland Supreme Court makes it right.
We are grateful to have had the opportunity to present our argument to the Supreme Court. Adnan has been home with his family for a little more than a year now, after decades of fighting to prove his innocence. This appeal is about whether Mr. Lee's rights were satisfied by his remote attendance at the vacatur hearing, and whether the state had the power to decide it no longer wished to prosecute a case it did not believe in. Yet it is Adnan whose liberty is at stake. The death of Heyman Lee and the loss suffered by her family is unquestionably tragic. So too is the incalculable loss that Adnan and his family have suffered when he spent over half his life in prison for a crime he did not commit. We look forward to the court's decisions, and we're hopeful that the justices will choose to leave Adnan where he is, where he belongs, with his family. Adnan would like to make a comment.
We just wanted to say thank you to everybody for over all these years who just provided us with all the support and the encouragement. Our family, it just means so much to us, and we look forward to hearing the court's decision, and we're hoping that in the end, we'll have a chance to prove justice, not just for Hay's family, but for our family as well. We believe very strongly in trying to find justice for Hay and her family, and we're just hoping also that we're able to find justice for us too. Thank you.
Maryland's Supreme Court justices will not make a ruling today, but they should rule soon. We'll keep you updated. In Annapolis, Mike Helgren, CBS News, Baltimore.